Barry Stahl, Law and Order, Corporate Intent. Even better.
In the privatized arbitration system, disputes involving corporations are diverted into a shadow process where public accountability is replaced by predefined outcomes favoring the rich and powerful. These are the protections we are forced to surrender. Dun dun. Any dispute of any kind shall be submitted to binding arbitration before a single neutral arbitrator knowledgeable about the industries. This is from a book contract. But it isn't just a publishing thing. The same mechanism is in nearly everything, from application agreements to Zumba registrations. The corporate intent unit was called in to investigate. I'm Detective Robert Golem, and this is from my case file. I interviewed several witnesses for this investigation. First up was the publisher, Cuyahoga Press, the repeat player in this arbitration process. I asked for this senior VP who signed the contract in question. They sent their associate general counsel. She explained the process to me, including how arbitrator selection works, with both sides striking names from a list provided by the American Arbitration Association until one is agreed on. She minimized any concerns about how often Cuyahoga goes into arbitration, the availability of arbitrators who are familiar with the industries, and the overall fairness of the process. She assured me that despite the ubiquity of these clauses, they are not intended to be coercive, that they provide a faster, less expensive resolution to disputes for both sides. Finally, I asked why they felt these clauses were even necessary. The General Counsel reiterated that arbitration is an impartial process that is cheaper and faster than litigation. She insisted that both sides benefit, citing a 2022 report from the U.S. Chamber of Commerce. I'd heard the company line and wanted an individual's perspective. Since most cases are settled under a non-disclosure agreement, I reached out to an advocate who has worked with many in this system, Dr. Marcus Hale, Senior Policy Analyst for the Midwest Center for Fair Contracting. Dr. Hale informed me that despite the Chamber of Commerce's protestations, there's 30 years of real evidence from many prestigious institutions that the repeat player advantage is real and that arbitration favors businesses over individuals. Dr. Hale made it clear that there was no real choice, that binding arbitration clauses are usually adhesion clauses, where individuals had to accept these terms or walk away due to the power imbalance. He told me that the evidence is overwhelming. Arbitration protects companies at the expense of individuals, and that individuals have no real choice in agreeing to these terms. I'd finished the interviews, the evidence was solid, the pattern was clear. Now it was time to bring the case to someone who could do more than talk. District Attorney Claire Kincaid has seen cases like this before. I told DA Kincaid what I'd found, that once you're in arbitration, the game is already over. She already knew that people were being funneled into what she called a simulation of justice. She told me, "You're not asking me to prosecute a company, you're asking me to prosecute the system that protects them." She wasn't wrong. Kincaid said this system survives on the fiction that people have agreed to it. But these clauses aren't negotiated. Most people don't even know they're in the contract until after they're already committed. Courts call it consent, but she called it take it or leave it, disguised as a choice. And once in, it's as if your lawyer negotiated every word. The DA then told me arbitration doesn't just hide the outcome, it hides everything. From the moment the clause is signed, everything moves into the dark, with no way for anyone else to know what happened. That darkness keeps the system lopsided. We, the people, walk in blind, but not the companies. Signing agreements with these buried clauses doesn't just cost us a jury. It costs us a right to petition the government for a redress of grievances. That's right. Our First Amendment rights can be signed away with just a checkbox. You think that'll work with the Second Amendment? Congress has tried to fix this. The US House passed the FAIR Act in 2019 and again in 2022. Both times it went to the Senate Judiciary Committee and never even got a vote. Back at the office, I noticed Dr. Hale's pamphlet. A few lines jumped out at me. It read, "Some contracts include a window, often 30 days, where you can opt out. These usually require sending a USPS letter. If you have this option, use it every time, even if you think the window has already closed." Good advice. I also found my list of possible witnesses. Unlike the other groups in this story, where the names were changed to protect the guilty, these groups are real and are doing the hard work of fighting to protect our rights. I thought about how Congress tried to fix this, and it didn't even get an up or down vote. That's what stuck with me, the pattern. A system that keeps disputes hidden, a reform that never gets a public vote, a right that disappears in the fine print. I've put this case file online for your reference. For now, the case remains open. Dun dun.
Barry, you're much cuter than John Lee anyway. And you also have me scared to death. But that's okay.